The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. Before we begin, let me just announce the cases that will be heard and submitted this morning. They are State of Iowa versus Zariah Schlitter, State of Iowa versus Iowa District Court for Dubuque County, State of Iowa versus Andrew Lopez, and the final case is State of Iowa versus Joseph Soretti. That last case is submitted without an argument this morning, and we'll now hear the arguments in the Schlitter case. Ms. Knipfer.
May it please the court, counsel. A defense counsel has a duty to zealously represent his or her clients, and part of that duty is to know the law. In the present case, trial counsel breached his duty in a number of ways, the first of which is that he failed to make a proper motion for judgment of acquittal when he moved for judgment of acquittal in murder in the first degree. The problem here is that he stopped at that point and didn't move for judgment of acquittal on the lesser included offenses, and even worse, he conceded that there was sufficient evidence to move to present to a jury the child endangerment charge, which we now assert that there was not sufficient evidence to move to a jury. The defendant was convicted of involuntary manslaughter by criminal offense, and defense submits on appeal that there was not sufficient evidence for this conviction, in part because there was no criminal offense here, the criminal offense being child endangerment.
Well, let's take a look at the child endangerment statute. As you know, it has four separate prongs, if you will, stated in the alternative: knowingly acting in a manner, et cetera, an intentional act or serious, et cetera. Wasn't there sufficient evidence, surely, to show D, for example, that your client knowingly permitted the continued physical abuse of KS?
I think, well, if you look at his statements in his interview with police, I mean, he continually saying, I didn't know, I didn't realize, he's not, he thinks that Amy Palmer is a good caretaker. He says, well, she treats her children
Sure,
well.
that's his position, but the question on D is, could a reasonable fact finder conclude, well, maybe he wasn't the perpetrator of the abuse, but he was living with this woman. The abuse occurred over a period of several weeks. He must have known. He's not an idiot. I mean, he's living with her. He's around the environment. He's taking the child to clinics with various maladies and so forth. He's got to be observing what's going on, and it may be that he arguably didn't hit her or didn't do the abuse himself, but couldn't a rational jury say the relationship between your client and Palmer was so close, and that his proximity to the child was so close, that he must have known what was going on? Couldn't a reasonable jury find that? Help me with it.
We need to look at a couple things here. One, it's not a should have known, it's that he had to have known test, and also there are a number of actors involved in here, and this only takes place really in about a 2-week time span, because when she goes to daycare, or she goes to the doctor on the 1st for her well check, she's fine, healthy little girl. And she goes through the week at daycare, she's a fine, healthy little girl. Then she shows up the 2nd week at daycare, and the previous night, Miss Palmer had watched her while he went to church for a financial class with his grandmother. Palmer watches her. The next morning, she has these bruises, and then that happens that week. Then the next week, the same thing happens, and then the following Sunday is when the 911 call.
I think that's the essence of the evidence, but if I understand this correctly, there are the predicate offense that we're talking about here is child endangerment. There's 4 alternatives in which to commit child endangerment, and if you can establish that any one of those 4 alternatives should not have been given, then it would be ineffective assistance of counsel to permit the court to instruct on the alternatives. Give us your what alternative was not, give us your best shot on which alternative was not established by the evidence.
Well, I don't think any of them were, but
Right,
I think
but
what
give
the
us your-
jury,
the
I
best
think what the
one.
jury was thinking was that it was the 4th one. And what's going on is we need to, back to Justice Apple's question, it's in such a short, we're talking a short time period here, really 2 weeks. And she's sick, and his focus is on she's sick. Why is she sick? And he keeps taking, to the doctor. And it's not just Zyra that doesn't recognize what's going on here. It's the medical community, the DHS worker, his grandparents. Nicole doesn't recognize what's going on here. She says in her testimony that she tried to see KS at least 3 times a week. I don't know that she did 3 times a week, but she is seeing the little girl. And nobody involved in this little girl's life said, hey, something's going on at Amy's house, and this little girl's being abused. Nobody saw it.
Does the knowing in the statute have any time reference? For example, if the jury would found he knew the night before the child died, is that enough, or do you have to know at a sufficient period of time ahead of time in order to prevent the bad conduct from happening? Because I understand the jury, I sort of agree with Justice Apple, the jury could have surmised that at some point in time he knew something was going on. Or the problem is, does that no have to be at a certain point in time when the abuse was going on under the statute, and how would you interpret it?
Well, it says he knowingly permitted, and I think, it has to be a sufficient amount of time that we can see that he was actually permitting this abuse to take place.
Oh, so what you're saying is that he'd have to know it happened, and then after he knew, he'd have to let it continue.
Correct.
So it couldn't be knowing the day he took her to the hospital.
No.
So it has to be knowing in some time before then. But what point in time in this case would it be under these facts in order for him to be convicted under the optimum conditions? What date would he have to know? Would it be right before the last trauma to the child?
Well, I think it would have to be before he left her the last evening with Ms. Palmer.
And that was the financial meeting at the church?
He goes to church with his grandmother for this financial, he had gotten into some financial difficulty, and so it was kind of a course to teach him how to get out of it and get his...
Well, but I don't think that's quite right. The medical testimony, at least, was rich and varied. But there was medical testimony that said, well, there was a acute trauma, if you will, that caused the immediate presenting injuries, and the testimony varied as to whether that injury occurred immediately before bringing to the hospital, or maybe 6 hours before, or whatever. But there was I think maybe even a consensus that there was a trauma causing injury within the very recent past. But there was also testimony that there was continuing abuse that projected back from the event. So couldn't a reasonable jury conclude, well, we had a course of abuse. It began, I think, 10 days before, approximately, maybe, but considerably before the trauma-causing event. And what does he do? Yeah, he does nothing. He covers up for her. He does take the child to the doctor, but he may, when there's questioning about some bruising and so forth, he's saying, well, she fell and ran into a table, I think he says, and then opened up a closet and the playpen fell on the child. So if he was aware that there was a problem a week prior to the injury, wouldn't that be enough to convict him under D?
Well, he would have to be aware that Amy is abusing her.
But, he came up with, at one point, he came up with kind of a cock and bull story, didn't he? I mean, quite frankly, he kind of says, well, opened up the closet and the playpen fell on her, and then again, he said something about hitting her head on corner of a table, I think. I mean, it's like, if she fell down the stairs. I mean, isn't this kind of the stuff that we get in child abuse cases all the time? And couldn't a jury kind of think that was just...
Well, in this situation, I mean, it's not clear to me whether Amy told him the playpen fell on her or he was there. I'm unclear on that. But, he just accepts what Amy tells him. And, I mean, that's not so out of line. He thinks she's honest. She's his girlfriend.
Let's look at B under the statute, if you will. And the alternative B requires an intentional act or series of intentional acts using unreasonable force. So in other words, under B, the actual abuser needs to be your client. The state suggests, well, there was evidence of that because the record showed that on occasion your client would become frustrated with KS. There was testimony, I think, about picking the child up roughly out of a saucer of some kind, and testimony that your client sometimes had a temper issue. Could a reasonable jury infer from that evidence, and maybe the state has more evidence, we'll probably hear that when the state gets up, but can a jury reasonably infer, well, he's a hothead, he's got some temper issues, he's on occasion roughly picked up the child, he's probably intentional wrongdoer.
When you look at the things that they said, first of all, they also combined it with how he was a loving father, and they totally, Nicole totally entrusted him with her daughter. But the types of things that they talked about are things that not going to cause the type of injuries that this little girl had. I mean, picking her up out of the walker too quickly, that happens, and he felt terrible when it did happen. And the grandmother said she went downstairs and he was consoling her, it felt bad. Sitting her down too roughly, again, that isn't the kind of thing that's causing these head injuries. And none of them, there's no evidence that, as I said, that those were the kinds of injuries. I mean, what the injuries that she was incurring were head injuries. And also, the injury, I mean, I know that the testimony from the doctors is, well, it could be, here to there and when it occurred. But a majority of the specialists said, well, it could have been a minute, right before or immediately before, up to 6 hours or up to the day and
What about the evidence that King, I think, testified that the defendant had a short fuse and that he was often rough with her, the way that he would treat her and picking her up and dealing with her in various ways?
Well, I don't, she said he could be rough with her, but it wasn't often, and it was It still wasn't the
Well,
type of.
for a
it-
short
type of-
period of time, it was 2-week window, it did seem to be a lot of, wasn't there he squeezed her face or something like that?
When he was giving her, his grandmother said that when he's trying to give her the medicine, that, he'd have to hold her cheeks because she would fight with him. And so he'd hold her cheeks and try to get her to take the medicine. And he finally, at one point, resorted to getting a eyedropper or something and would give her her medicine. I mean, I think the bruises on her cheek are probably from
Well,
Isaiah.
I mean, a jury could obviously conclude that one of the two caretakers did this to this child. And so you have to look at what could the jury do to reasonably conclude that one did it over the other? And wasn't there an abundance of evidence that King was rough with the child, that King was frustrated with the child as she was getting older and active, and plus there was numerous incidents of where he treated her in a rough way? Is that enough?
No. I mean, all parents get frustrated with their kids. Maybe they don't handle it the way Zyra did, but all parents do get frustrated. But he did not do those injury, whatever that fatal injury was, the night that 911 was called. Because I think the majority of the testimony is that it probably happened immediately prior to her posturing. Thank you.
Ms. Pettinger?
May it please the court, counsel. This court should affirm the defendant's convictions. There's substantial evidence supporting each of the four alternatives of child endangerment.
Talk about B. Where is the evidence that Schlitter committed an intentional act or a series of intentional acts that resulted in the death of KS?
I think we have to look at the timing of the older of the two traumatic events that led to her death. Several of the doctors testified that that particular injury would have occurred between 24 and 72 hours before she arrived at the hospital in distress, and one doctor thought it was even more than 72 hours. That time period coincides with the time that the defendant was watching the little girl by himself without his usual help. His grandmother and grandfather had to leave town. They were gone from March 18th through the 21st. So he was watching her on his own at that point.
There's a video of Schlitter playing with the girl the day before she's taken to the hospital having lost consciousness. Mm-hmm. And I have to say, she looks, other than there is some bruising, but she looks fine. And he seems like a very loving father.
I think he was in many ways.
But then what we do know is the next day, what we know for a fact is he leaves KS with his girlfriend Palmer, mm-hmm. and then goes to this thing at the church, and then 2.5 hours later, what we know is the girl has lost consciousness. She suffered fatal injuries inflicted by somebody.
Correct. And
he wasn't there the last 2.5 hours, right? So isn't it just speculative that the argument that he committed an intentional act resulting in her death?
No, Your Honor. Again, the medical testimony established that the earlier traumatic event, the earlier of the two, led to her death. There were two traumatic events. One took place shortly before 911 was called, but the other one took place from 1 to 3 days before that, possibly even more than 3 days.
I mean, I think, frankly, the testimony there was a little uncertain.
Yes.
And to credit the doctors, really, because, I mean,
Sure.
they don't know for sure, and
No,
they're making estimates. And I think it's clear, and you get half a point for sure. I mean, there was an opportunity for him to have committed serious direct injury to the child. I think there's no question about that, and a reasonable jury could conclude the opportunity was there. But you've got to go a step beyond that.
Well, I think you're right, Your Honor.
You know, and some of these things, I mean, the frustration business, and, you know,
Lack of other caregivers, a lack of a safety valve, where he would remove himself from the room on occasion earlier, and that wasn't an option when his grandparents were out of town. But I think another factor that does point to his causing serious injuries intentionally, the nature of the injuries too. There was bruising on her face, that indicated that somebody had grabbed her face violently, to cause bruises. And his grandparents had testified that on occasion when he was trying to give her his medicine, trying to be a good dad, he would get frustrated and grab her face quite violently. And the other thing was the mouth injuries. There was a torn frenum, the tissue in the mouth, and the doctors testified that it was as bad an injury of that type that they had ever seen.
Yeah, but I have a problem with the statute, and maybe it's relevant, maybe it's not. But child endangerment not resulting in death has one less element. And the element of child endangerment resulting in death requires that the defendant's act resulted in the death of the child, okay? So does the defendant have to know that the abuse that he's permitting to continue, which is one of your theories, or that he acted in a manner to create a substantial risk, was such that it would result in the death? And it seems to me that if you don't have that requirement, you end up with a strict liability statute. Well, if the kid's not hurt, if the kid's not dead, then it's a different class felony. But if the kid's dead, then you have a Class B felony with minimum 50 years. Don't you have to prove, and this is maybe where I'm having my trouble, that the abuse, let's assume he permitted it and there were bruises and things, but the abuse that he permitted to continue, or the risk that he put the child to, he knew was going to result in the child's death. And that I don't, what's the state's position on the statute?
I don't agree with that, Your Honor. It simply doesn't say that in the statute. It says he has to know that he's creating a substantial risk to her in terms of the first alternative, a substantial risk to her physical health or safety. None of the other alternatives are worded in a manner that would make him...
But the jury was instructed, which is the law of the case, there is a causation element in this instruction.
It had to lead to her
that the
death.
defendant's act resulted into it.
Exactly,
So
but he didn't have to know that it was going to result in death. I don't
Strict
think
liability, depending on the injury.
if that's how you want to term it, yes. I just don't think there's anything in the statute that suggests that he had to know that his actions were leading to her death, or that Palmer's actions were leading to her death. He did have to know that there was a substantial risk to her health and safety.
So the criminal act is based upon there were really 5 or 6 or 7 elements in the statute, but proving one of those elements and the penalties related on the severity of the injuries, is that the state's position?
Could you ask me that again? I'm sorry.
I'll try to remember it.
Okay.
The statute has like 4, 5, 6, 7, or 8 different ways
Correct.
you can commit. So the crime actually is violating one of those 4 to 8 ways you can violate the statute, and the penalty is based on the results, whether it's death, whether it's severe injury, or whatever.
That's right.
Is that the state's position?
Yes.
I want to ask about the Musser issue. And I read your brief closely, and I've read Musser, and I obviously reviewed the transcript. And it seemed to me, in reading your brief, you didn't defend the comments on the merits. You focused on prejudice. And do I conclude from that you do see a Musser problem? I mean, Musser kind of makes it clear that you can't talk about larger duties outside the fact-finding and following the instruction process. And it seems to me you've got a problem there in some of the language. Now, you go on and say that, I mean, I understand your argument that it's not prejudice and so forth and so on, but am I right that you kind of concede that there is a Musser problem here?
I didn't go so far as to concede it in the brief. I think I said that it could be approaching a Musser problem. I don't think it matters to my argument whether I concede that or not. I will say this, it certainly approached that type of a problem. I don't think the
Frankly, we seem to
prosecutor
get that.
intended it that way.
We get a fair amount. I mean, Judge Mullins, had a kind of an interesting observation from the Court of Appeals fairly recently about prosecutors kind of approaching the line. Someday you're going to go over the top.
Right.
And our case law also suggests that in the prejudice analysis, the question of how close the case is on the merits is a factor to consider, which seems kind of obvious.
That's right.
Give me your best shot at why it didn't cross Musser. I mean, I guess you can go up to the line and not over it, so give me your best shot on that. And then B, in light of some of the discussion here about the evidence, even on prong B as being maybe not as strong as other prongs, does not the fact this is a close case suggest that maybe the Musser problem is a reversible error?
The reason I think Musser was not prejudicial was, number one, it didn't seem to, the prosecutor didn't seem to be suggesting that the jury should convict the defendant on a ground other than what was in the evidence. He used some lofty language. It was an emotional case. I think everybody was very emotional about this.
Solemn and sacred duty of protecting the safety of the public and the innocent?
That is something that our courts have expressed concern about, and I think that does approach being a problem. It wasn't focusing on any particular evidence or any particular witness or any particular issue. So in that regard, it wasn't detracting from the defendant's defense. And it was quite isolated too. These closing arguments were very lengthy. I think the state's closing argument was something like 65 pages, and this transpired during 2 of those pages. So even if it did cross the line, I think it was isolated enough. It didn't really attack the defendant's defense so as to denigrate, the defense that he was trying to present. That would be my argument. I'm sorry, I forgot part B.
Part B was to try and distinguish Musser and say it didn't fall within the scope of Musser, but some of the points you make were also present in Musser too. Musser wasn't exactly a commentary on the evidence that was improper. It was if you don't hold them accountable, nobody else will. It was one could argue Musser was a rhetorical flourish too. And it seems to me the thrust and spirit of our case law is, look, we want jurors to follow the instructions, and we want them to evaluate the evidence fair and impartially. And we don't want rhetorical flourishes that might emotionally move the jury.
True.
At least from my reading of the cases, I think you've got an issue here.
Oh, and then you were asking the fact that you felt that some of the alternatives weren't real strong. Doesn't that make it more prejudicial? Well, I think we can point to one alternative, D, that is just practically ironclad.
Well, that may be, but that takes you to the next question, which is, if you have a general verdict here.
Exactly.
Yeah, and so if you're flawed on one theory, it seems to me you got a problem. I mean, the jury, you don't know if 4 people voted this way and 8 people voted that way. So.
Well, of course, the state is not conceding that we're flawed on any of the alternatives, but if that were the case, this court could affirm on the strength of the alternative for which there is sufficient evidence.
Let me ask you one question about Miranda too, if I can.
Okay.
Just briefly, there's one aspect. There's a number of aspects of the Miranda, but I want to dwell on one thing, and that is During the course of the interrogation, there was repeated requests from the defendant to stop the interrogation. Schlitter says, I mean, it's getting kind of accusatory, frankly. I mean, they're really zeroing in and they're saying, look, and he says, stop it, it's getting too graphic, stop it, I think 3 times. But the questioning continues. Isn't that a request, I mean, really to remain silent? He says, stop it, but you bowl right over it. And
I
then,
think he was objecting to the nature of the question. That's my take on it.
Well, so he says, stop it, and they don't. He says, stop it, and they don't, and stop it, and they don't. Does he think he's free to leave?
He apparently did, because he told them he was expected at his family's to eat pizza, and he left.
Well, later on, and let me share a theory with you that I want you to be able to tackle here. And I'm looking at just part of this interview. I think it may be fair to say that part of it wasn't custodial, actually. All right, the invitation to come, you know, was comparatively mild, and he drove his own car and so forth. And when he arrived there, it probably wasn't custodial. But then it did turn, the questioning turned accusatorial. And the case law, Miranda case law, suggests that it can morph from a non-custodial interrogation into.
Absolutely.
And I think that only makes sense. So we're focusing on the part of the interview where he says, stop it, it keeps going. Then ultimately he also seeks to talk to an attorney, and they stop the interrogation, and he calls and leaves a message apparently doesn't get, but then they continue questioning. When things got going in the interview, would a reasonable person really think he was free to leave?
Oh, I think he unquestionably felt he was free to leave. I think he didn't like the tone that the questions were taking. I don't know that I quite agree with your characterization of the questioning as being accusatorial. I think they were getting a little frustrated. But we have to remember they didn't have all the medical reports back. He wasn't charged for another 15 months. I think they were getting heated. They weren't getting...
They had 2 suspects, I mean, quite frankly.
Yeah, exactly.
I mean, it wasn't quite, hey, we've got a crime, come on in and talk about it. It
Well,
wasn't
that is
quite
true.
that.
That is true. But they were having trouble getting any kind of information out of him, and I think it did become a little more heated. Not to the point where they were actually accusing him of doing anything. And the stop it, he didn't like hearing about graphically what some of the injuries
Well, I don't
were.
know, one of the questions right before we need to stop, somebody abused your daughter and she died from it. I need to know exactly how it happened. One of 2 people did it. I mean, that strikes me as really focusing in on determining the defendant's guilt. Now, that's not the end of the Miranda issue, of course. But
I don't think, though, that I don't think that the tone of the entire interview was that way. It got that way.
I agree. I agree with that absolutely.
At one point. But overall, I think that this was a request to get information. And then when he decided he wanted to leave, he did leave.
Counsel, before you sit down, I want to go back to the 4th prong of the child endangerment statute,
Yes.
the knowingly permitted abuse provision.
Right.
And I'd like you to give me the state's best interpretation of the evidence, summary of the evidence, during that 2-week period, the crucial 2-week period, with respect to the evidence of bruising on the child's body that supports your position that a reasonable juror could have found beyond a reasonable doubt that he knew that he was exposing his daughter to abuse before that last horrible trauma.
The first 2 Mondays that she, or well, I'll say March 8th and March 15th, both Monday mornings when she arrived at daycare, she had spent the previous night at Amy Palmer's, and he had gone to his class so that Amy Palmer was her exclusive caregiver. As I say, she arrived the next morning. On both of those Mondays, she was exhibiting fresh bruising, and it was to the point where the 2 people who spent the most time with her, the 2 caregivers who actually did the hands-on care with the children, were very concerned. They took pictures, they reported it to their supervisor, who thought that the explanation given was reasonable. In
Okay,
addition,
and then during that 2-week period, at the beginning of the second week, didn't the defendant take the child to the doctor?
he did take her to
Yeah.
the doctor, Your Honor.
And
but he
did the
not-
doctor report the abuse at that time?
No, the doctor, or I think it was a nurse practitioner. No, I don't believe so. What I have to say to that, in some respects, I don't understand why more action wasn't taken. But on the other hand,
Well, we
he did
can't-
not tell the nurse practitioner of the most serious symptoms. He said, well, she's got a fever, she's pulling at her ears, she's got a
Yeah,
runny nose.
well, I'm not focusing on the symptoms so much as the physical evidence of the possibility of abuse, that is, the bruising piece. And what I'm struggling with is this question of whether, at what point during that 2 weeks should the defendant have known, or at what point could the jury have concluded he knew that she was being abused by Palmer?
The first Monday on March 8th, the daycare workers observed that some of the bruises were covered with makeup when they were cleaning her face. He at first professed not to know about that. He later finally admitted that contrary to what he had earlier said, he did see bruises on her, and he did know that Amy had been putting something over to cover them. So he was aware of that as early as March 8th. And then as things got worse, she started exhibiting symptoms that he was not reporting to the nurse practitioner. Horrible symptoms, pulling out her hair, screaming, having nightmares, trying to swallow her food without chewing, losing her verbal skills. There was obviously something extremely wrong with this little girl. Thank you very much.
Thank you as well. Rebuttal?
There are a couple things a lot of things I'd like to say. One thing that you need to look at is that when KS seems to be starting to get sick, it's Monday, and then by Friday in both weeks, Friday and Saturday, she gets better. On the first Saturday, her fever breaks and he goes to Amy Palmer's house. In the second week, she's sick, but then she gets better, and we see the video
Let me
recording.
follow up on that. Ms. Pettinger talked about medical evidence that there were 2 traumatic events, and perhaps the defendant inflicted the first of the traumas. Is there any evidence in the record that the first traumatic event, without the second one coming along, would have resulted in the death of this child?
No, not that I remember. They talk about there are likely 2 traumatic events, and I mean clearly there were 2 traumatic events, but the fatal blow.
I'm not so sure that's clear, but there was one witness that said that. Let me ask you what when I clerked on the Fifth Circuit they used to call friendly questions. Let me ask you another friendly question. There's this 50-page Court of Appeals opinion. It's a very thorough opinion, and I've read it carefully. But when it discusses Alternative B, at the conclusion of the discussion, the Court of Appeals says there is substantial evidence Schlitter intentionally inflicted injuries on KS that resulted in bodily injury, Alternative B. Isn't that perhaps not exactly what the instructions in the law require? Don't you have to have intentionally inflicted injuries that resulted in death?
Under Alternative B, well, right, because those serious injuries resulted in KS's death.
That burden perhaps not quite correctly stated in that
Right.
portion of the Court of
Right.
Appeals. Thanks.
Yeah, is each of these, whatever act they're talking about, the acts have to result in the child's death.
What do you make of the Musser problem?
The Musser problem, I think it's a huge problem under this case because, again, even if we accept that there was sufficient evidence to present this case to the jury, then the prosecutor, and this prosecutor was very adamant in his belief in this case, and he got in there and he waved the flag and he talked about their duties, and he talked about, you know, particularly the safety of the public and the community. And we have what we have here is the death of a beautiful, charming little girl. You know, so all those emotions come welling up to the surface.
It was part of I must say, the closing argument was quite lengthy.
Yes.
And
But those are the final words that jury hears from the prosecutor. So I do believe it's a problem, and particularly in a case like this where the evidence against the defendant really teeters between speculative and actual evidence.
Counsel,
If we-
four alternatives were submitted and then a general verdict, so we don't know which one the jury, or which of those the jury may have concluded applied. If we find that the evidence was insufficient on any of the alternatives, is a new trial required?
I believe a new trial is required because there is always the possibility that a juror believed him to be guilty under that alternative which should not have been submitted.
The question, I just want to follow up, because if we find insufficient evidence on 1, 2, or 3, or less than 4 of the things, doesn't he have to be acquitted on those? I mean,
Yes.
would that be an acquittal? So he only could be retried on the ones that we did not find insufficient evidence?
Yes. And when there's been a lot of discussion that Isaiah would get frustrated, but also in the record, it talks about when Isaiah would get stressed, and this comes from the grandmother, the child's grandmother, Nicole's mother, and Isaiah himself, but that when he would get frustrated, he learned from Daddy Boot Camp, you leave the room. And the prosecutor made much ado about that, but that is exactly what he should have done. So, I mean, yes, he may have gotten frustrated. Every parent gets frustrated with their kids sometimes. You get up and you leave until you cool down. I see my time is up. Thank you.
The case is submitted. We'll now hear the arguments in State versus Iowa District Court for Dubuque County.